Tinker v. Des Moines Independent School District was a 1969 Supreme Court case that established the First Amendment rights for students in public schools. The case began when school administrators suspended 5 students for wearing black armbands to school that at the time symbolized their opposition to the Vietnam War. Denouncing the war effort was very unpopular among many people, and the school defended their policy of suspension by saying the wearing of the armbands could lead to fights or other violence on campus. The students were told that they could not return to school if they continued to wear armbands. Their families sued, but both the district court and the appeals court decided in favor of the school, citing the need to prevent violence or disruptions to school. The Supreme Court, though, overruled the lower courts, deciding that without good reason to expect disruptive behavior, students still had their First Amendment rights to free expression. In this case, the Supreme Court noted that the students were peaceful in their protests and there wasn't any violence. But the court's majority opinion left open the possibility of schools prohibiting speech, even political protest speech, that did cause substantial or significant disruptions in school operations. But the school can't just say that they fear violence could possibly happen, unless the school has good evidence that the violence is a real possibility. The court also noted that the First Amendment is designed to protect the views of groups in the minority. Obviously, the most popular and common views don't need the protection in a republic. It's the views that are outside the majority that need protection. Over the decades since Tinker, there have been other cases clarifying that schools can prevent expression that will cause disruption or otherwise interfere with the purpose and function of schools. For example, the Supreme Court upheld the expulsion of a student who had a sign saying "Bong hits for Jesus." In that case, the court ruled that it wasn't political or religious speech because the student wasn't trying to affect politics or express sincerely held religious views. And further, the message the student was expressing went against the school's legitimate interest in discouraging drug use. So as a high school student, you can take away from this that you do have freedom of expression while a student, but that freedom is more limited than in your general public life. You can express many ideas, including political or religious ideas, but you can't create a situation where the actual function of the school is negatively impacted. In 1967, during the Vietnam War, the Secretary of Defense, Robert McNamara, commissioned a secret government study on the involvement of America in Vietnam. When it was completed in 1968, the report was 47 volumes and more than 7,000 pages. It was considered a classified document and only 15 copies were made. A few years later, in 1971, Daniel Ellsberg, one of the people who had developed the report, secretly made copies of the documents and passed them on to the New York Times. After several months of reviewing the documents, in 1971, the New York Times began to publish these documents, which became known as the Pentagon Papers. After the first 3 installments were published, President Nixon's administration, citing national security concerns, went to a court and got a restraining order that barred the New York Times from continuing to publish the papers. The New York Times appealed to the Circuit Court of Appeals, which affirmed the restraining order and wouldn't let the New York Times publish them. So then the New York Times made an emergency appeal to the Supreme Court, which agreed to hear the case the very next day. The question the court had to answer is this: did the Nixon administration's attempt to stop the publication violate the New York Times' First Amendment freedom of press? In a 6-3 decision, the court ruled in favor of the New York Times and allowed the Times to continue publishing the Pentagon Papers. The publication of the Pentagon Papers became a major part of the anti-war movement and helped lead many Americans to conclude that we could not win the war, and so we needed to end the war. In the majority opinion, the court said that for the government to prevent a newspaper from publishing documents, the government would need to show that the publication represented a serious threat to the country or a direct threat to the American military personnel. In this case, the court decided that the government had not shown that publishing the Pentagon Papers rose to that level. Another important case is Wisconsin v. Yoder. Jonas Yoder and a couple other members of the Amish community and a Mennonite community, which is another conservative religious group very similar to the Amish, were prosecuted under a Wisconsin law that required all children to attend public schools until the age of 16. The 3 parents refused to send their children to high school after the 8th grade, arguing that high school attendance was contrary to their religious beliefs. It was acknowledged that the Amish people did provide informal job training for their teenagers that was designed to prepare them for life within the Amish community. The court determined that Amish sincerely believed that high school attendance was contrary to their Amish religion and way of life, and that attending high school would endanger their own salvation and the salvation of their children. So the question the court had to consider is this: did Wisconsin's requirement that all parents send their children to school at least until the age of 16 violate the First Amendment freedom of exercise for the Amish and Mennonite parents by criminalizing their religiously based refusal to send their children to school? The court ruled in favor of the Amish, in favor of Yoder. The court ruled that an individual's right to free exercise of religion under the First Amendment outweighed the state's interest in compelling attendance beyond the 8th grade. In the majority opinion, the court found that the values and programs of secondary school were in sharp conflict with the fundamental mode of life mandated by the Amish religion. In other words, what students learned in high school did go against what Amish people believed. And further, the court concluded that the benefits to society of a couple more years of school weren't enough to justify restricting the free exercise of religion. Next, we have Nixon v. United States. President Richard Nixon's administration became entangled in a scandal known as Watergate. Several people close to the president were indicted on criminal charges, and the prosecutor subpoenaed documents or requested, demanded documents and tape recordings from President Nixon that could be used as evidence. But Nixon refused to turn the documents over, saying that he had executive privilege through the separation of powers, saying that certain documents related to one branch of the government, in this case the executive branch, couldn't be taken by another branch, the judicial branch. So the question the court had to answer is this: does the president have the right to safeguard certain information using executive privilege, confidentiality from judicial review? The court decided that no, the president does not have an absolute executive privilege immune from judicial review. The court held that neither the doctrine of separation of powers nor a generalized need of confidentiality of high-level communications gave the president an absolute privilege. The court granted that there are limited executive privileges in areas of military or diplomatic affairs, but the court said that when it came to matters of maintaining the rule of law, the president did not have an absolute privilege. Therefore, the president must obey the subpoena and produce the tapes and documents. Nixon ended up resigning as president shortly after the release of those tapes. This case represented a landmark decision in the constitutional principle of the rule of law. Nobody is above the law, not even the president.